breaking and entering, drunk and disorderly, law and order. A former prosecutor and a defence lawyer, not your typical pairing. And the result? Conversations about crime and punishment that are guaranteed to get you thinking.
Welcome to Justice Matters with Joe Crowley and Lizzie Green, a brand new weekly podcast. Our episodes are available on Apple Podcast, Spotify and YouTube. Check out our Instagram for clips at Justice Matters Pod. Enjoy the episode. This episode contains descriptions of violence, sexual violence, including violence towards children. Listener discretion is advised. Hello, Lizzie.
Hello, Joe.
How are you?
I am good.
All right. Well, I'm very excited to do this second part of our deep dive into the conviction and then acquittal of Raymond John Carroll for the murder of Deidre Kennedy.
Yes. So for anyone who didn't listen to our last episode,
yes,
you might want to go back and listen to that first,
yes,
because I did get quite immersed in the facts, and what happened was we spent an entire episode talking about the facts of the case of Deidre Kennedy and the murder of
yes,
her, and then the investigation into Raymond Carroll as the murderer.
Yes.
And we stopped after he had been acquitted of the murder by the Court of Appeal.
So he's convicted at the trial by the jury, and then the Court of Appeal acquit him.
That's right.
Quash his conviction and
so
acquit
he's
him.
now back free in the community.
And this is in 1985.
Yes.
So the murder occurs in 73.
Yes.
And then there's a long period of time with lots of investigation, which eventually ends up with him being
Tried.
charged, convicted, acquitted
And now
on
acquitted.
appeal.
Yes.
Yeah.
So we're going to pick it up from there because there's more to the story. This is quite, it's been quite a significant cases.
Yes.
Through the years.
Yeah. I think you said it was something you recall from your childhood. I certainly recall stuff about it from my childhood. And this was, we should say it again, thanks to our listener Jessica Hodge, who suggested this because she grew up out at Ipswich where this occurred. And although she was much younger than Deidre Kennedy would have been, she recalls it from her childhood, people talking about it and her father talking about it. So, yeah. Yeah,
it is one of those cases that I think just does grip the people who know about it because of, the tiny victim, the family heartache and the lack of justice at the end of the day.
Yeah, and that, as we said in the first episode, a parent's worst nightmare. You go to sleep and you wake up the next morning and one of your children has been abducted from the house and has been murdered.
Yes.
Yeah, just a horrible...
I literally can't even imagine.
Yeah.
I lost my third child at Big W one time.
Yeah.
For maybe 4 minutes.
Yes.
And I was beside myself.
Yeah, yeah.
Yes.
I know. I mean, anybody who's had children, I'm sure, has had a similar experience out shopping. And, yeah, it is just the worst feeling in the world that you don't know where your child is.
Can't even think straight.
Yeah.
So.
Yeah. All right. So he has been acquitted by the Court of Appeal and goes off to live his life.
Well, he moved interstate very quickly with his family after that acquittal.
And then the Queensland Police and prosecutors continue.
They do. So later that year, after he'd been acquitted, someone who'd been on the Air Force Base in Darwin at the same time that Carroll had been, it was a woman, recalled that back in 1975, she'd had conversations with Joy, the ex-wife, about the bruising on Raymond Carroll and Joy's daughter, which the ex-wife alleged to police he had bitten their daughter on her thighs when she was a baby, which led to the marriage breakdown.
Yeah, so the quick recap. So Raymond Carroll is observed by his wife having bitten his own daughter.
She didn't see him bite,
right? But
he was behind closed doors. The baby was crying, and then she would find the bruises afterwards.
Yes. They subsequently divorced because of that.
Yep.
And but that evidence goes before the jury as propensity evidence in his trial.
That's right.
And he is convicted. And then in the Court of Appeal, I think, were critical of that evidence going before them as well, on the basis that it was very prejudicial.
Yes. But so this new witness said she actually saw the bruises on Raymond Carroll's daughter back in, the 1970s and asked the ex-wife, Joy, about it. And she said at that time that they were bite marks. So any suggestion she had come up with this story down the track is now gone.
Okay.
This was corroborating evidence at the time that it happened.
Sure. Not sure it advances the case too much.
Well, it's interesting.
No.
But also then in 97, we had some advances in digital imaging techniques, which led to some groundbreaking developments in forensic dental technology.
Yes.
So this might be the rigorous testing you were hoping for.
Not according to the Court of Appeal and High Court, but yes, keep going.
So now they could do this thing where they could create a unique barcode from an offender's or an individual's teeth.
Oh, my Lord. This is just
because
you've already lost me.
you don't
so
understand it doesn't mean it's not good.
Well, assuming I am a reasonably intelligent person, then
you're not a dentist. New software had also been developed to help experts when they were looking at images of teeth and transpose them onto images of bite marks. So that sounds a little more rigorous than a visual identification.
Sure.
And so the evidence from Deidre Kennedy's case was re-examined. They actually discovered another set of much fainter marks that had been missed during the original examination.
Okay. That sounds very strange because they're working off, to remind everyone, photographs.
But they've got enhanced digital technology now.
Okay, well, I've done a case where they have photographs of an injury and then subsequently they talk about the photographs and what they see and, they've seen stuff later. And, it's all
right. Well, I don't even want to tell you the next thing.
Oh, okay.
But
tell the
turns
listener.
out,
I'll just sit here quietly.
Turns out that in light of the advanced technologies, the original odontologists had been looking at the bite mark upside down.
Okay, so right, so just remind them. I hope the listeners have listened to the first part of this and my criticisms.
That is a big revelation. I understand that, but regardless, with the new technology, with the new method, with the enhanced visuals, the forensic odontologist said he had no doubt at all about Raymond John Carroll being the person who had inflicted those bite marks.
Can I just say something about that?
What?
Because I am always very skeptical of scientists who say they have no doubt at all. Because when you talk to scientists, they mostly say, I'm pretty sure. They almost never nail the colours to the and say
maybe
it is
that
definitely
just really is great evidence against Carroll.
Oh, I think it always raises red flags with me. Can I also point out the confirmation bias that seems to be going on here? So they go, we've got this new technology, let's use it to analyse this old evidence and get our expert in and say, here's Raymond John Carroll, we thought he did it and he was acquitted. Can you just check with this new technology? So, if they're going in like that, the expert has a confirmation bias. They're not going, listen, here's 10 random sets of teeth.
Well, now I don't want to tell you the next piece of new evidence either.
Go on then.
So apparently, when Raymond Carroll was in prison,
yes,
he crossed paths with another
prisoner
called Trevor.
Okay.
And Trevor said that they were chatting and Carroll had asked him, do you know anything about bite marks? And he said, why? And that he thought they were as good as fingerprints, in Trevor's opinion.
Right.
Which seemed to unsettle Carroll. And so then they're still chatting and Swift tells Carroll what he got arrested for. And Carroll allegedly said he got arrested for the murder of the baby at Ipswich, and that a day or so later they were still chatting and Trevor asked some more questions. And Carroll said to him he'd been out stealing women's underwear when he stumbled upon an open window, looked in, saw the baby inside, things got out of hand. He abducted the baby and then abused and strangled the baby.
Okay. My first impression is that jailhouse snitch testimony is always unreliable. Now, having said that, the description of what
happened,
what was his name? Steve, Spike?
Trevor,
sorry. The description that Trevor gives is quite detailed, and so that tends, I think, on first blush, give it a ring of truth. So because, how does he know about these, the details? I mean, maybe he read it in the paper.
Well, he might have, because this conversation or these conversations would have taken place like in 84.
Yes.
And now we're in 97.
Yes.
So it's been some time. He hasn't come forward earlier with this information.
Yes.
He didn't tell anyone at the time. Oh, no. Actually, no, he did tell someone at the time.
Yes.
But that was a prison guard who's dead now.
Right.
So no good.
No.
Help. No help, sorry.
No help.
So they did think that this was worth noting.
Revisiting.
Trevor's information was of some value.
Yes.
So they knew that double jeopardy meaning you can't be twice put at risk of conviction for the same wrongful conduct. So because he's already been charged and now acquitted of the murder of Deidre, he cannot be retried on that charge.
Can we pause here and just unpack the public policy reasons behind that rule?
Yes, go.
So, I mean, it's an ancient rule that comes to us through the common law.
800 years.
800 years. Wow. And as I understand it, reasons behind it is because the prosecuting authorities, the Crown, have endless resources and endless time. So they could re-prosecute you, as much as they liked. They prosecute you, you're acquitted. They just get another jury, prosecute you again, you're acquitted. They prosecute you again.
You've never worked in a prosecutor's office. There is not endless time.
No, well, but sorry, there's endless time in that the prosecutor who retires is then replaced by another prosecutor, who then retires, who's then replaced by another prosecutor.
Yes,
so although the people change, the fact that it's an open file doesn't change. It's there and can be worked on.
Yes, all right.
And I mean, I've seen that not in the prosecution service, but in the police service when I've had clients, who've had very long-standing matters, and they're just. I had a guy who was pursued for a breach of parole, which was how many? It was 20 years earlier, the breach, and it was a breach of a suspended sentence. The sentence that he was convicted on was for an offence that had occurred 20 years before that. So it was a 40-year-old offence, and they were still pursuing him. So the people, the police who were involved in arresting him for the offence would have long retired, and he was still being pursued.
Was very bad.
Well, it was my client John Killick who escaped from Silverwater Jail in a helicopter. So
probably worth pursuing.
The authorities did not like him, so they certainly pursued him for everything they could. But I was surprised by the level of emotion that the prosecutors and police in that case showed when they were, some of them not even born when the offence had occurred.
Well, that just is reassuring to know that our police and our prosecutors are human and can have feelings about the matters that they are dealing with.
Sure. I mean, law, what is it? Law is reason without emotion.
And
that I think is an important aphorism to keep in mind if you're a prosecutor and a police officer.
Well, yes, and I am very firm in teaching my students that the prosecution do not act for the victim. They are there to serve justice. And I think that is the underpinning of prosecution, that you have to just present the evidence and not be invested if it's a not guilty verdict because you've done your job.
Yes.
But you also you don't want people who are dealing with victims, families, and accused and their families to not have empathy or an ability to feel.
Yes.
So,
sure,
you don't like their feelings towards your clients if they're guilty. That's, normal, I
even
suppose.
when they're not guilty. I don't like the feelings towards them. But the issue is particularly in a case like Deidre Kennedy, a child murder and just a really horrible child murder. I think I'm not saying emotions did play a part in it, but, you see from the fact that in the mid-90s, what's that, 20 years after the actual murder, the authorities are still, even despite an acquittal by a court of appeal, still interested in pursuing the matter.
I think, to be fair, though, to the police, I think if you search, you would find media reports that focused on Carol's acquittal and the lack of justice for Deidre.
Yes.
So I think there was never really, particularly locally, an abatement of the sense of dissatisfaction and outrage. And, that obviously we've talked about the role of the media, but it does, it kept it in the forefront of people's minds.
And I wonder how much the fact that he was convicted by a jury and acquitted on appeal had to do with it, because I find people have great faith in the jury service. I mean, it's one of the few rights in our Constitution are trialled by jury.
Well,
and so the conviction by a jury, I think people feel, is a much more solid sort of decision. Finding than some judges in their ivory towers who decide on some legal point that he should be acquitted.
Well, and I don't want to revisit things we've talked about, but Baden Clay was convicted by a jury, and the Court of Appeal took it upon themselves to change the jury verdict.
Yes.
And that, I mean, you think back to...
I think they did that rightly, I must say. I think the Court of Appeal in Queensland's decision was right in that case, and the High Court was wrong.
Let's not go down that path.
Okay.
But you think about in Brisbane, the reaction, the front page screaming headlines, people gathering to protest, because there was, I guess, let that jury verdict stand.
Yes. But I mean, what we've known for 120 years more, that juries can get get it wrong, and so our system has a fail-safe. The Court of Appeal.
That, according to your point, you'll either say we need to have utmost faith in juries, or we need to know juries get it wrong.
I think we should have utmost faith in the jury service, but understand they also get things wrong.
All right.
I think those two ideas can sit together.
I know you trot them out according to whatever point you're making.
Yes. All right. So the prosecutors and the police are pursuing this. They have these 3 new pieces of evidence or supporting evidence. The more evidence about Carol biting his own daughter, the updated odontology that
we should apologise
evidence.
To all odontologists.
Yes,
we're butchering this profession.
And the third one was I've forgotten it now.
The jailhouse snitch.
The jailhouse snitch. And so this is what they then decide. What do they decide to do?
Okay, so they cannot, according to law, retry him for the murder. But a little bit of thinking outside the box.
Which I think is always dangerous in a prosecutor, because they should be legally conservative.
But they should have no creativity.
I think creativity is dangerous in a prosecutor.
Whatever.
Yes.
I don't think it's a problem. So they decided to bring a perjury charge against Carol. And that's because at his original murder trial, he got in the witness box and he said under oath, I did not take and kill Deidre Kennedy.
Yes.
So perjury is where you have lied under oath.
Yes.
It is an offence and it carries a maximum of 14 years. It's deemed a serious offence by the courts.
Rarely prosecuted, though.
Rarely prosecuted.
Yes.
And I used to love it in my Beenleigh court when witnesses would come in to be sworn in, and our little bailiff, John, who I loved so much, he had a whole flip out folder of all of the different oaths and affirmations that you could make, and he'd flick it out and wait for the right one to come up. But I mean, it was a real process. You gave that oath or affirmation that you would give evidence that was true.
Yeah.
And
I mean, and those things that John are flicking out, just for those who didn't have the benefit of working as judges, clerks as we did, they are, you can be a Hindu and they've got the Hindu oath.
That's right.
You can be a Buddhist, they've got the Buddhist oath. They've got them all there. So if you want to take a religious oath, there's one there. If you want to take a civil oath because you're not religious, there's one there. So
covered every preference. And so that was always a huge part of the witness process.
Yes.
Anyway, so perjury trial.
Yes.
So he's brought to trial on that perjury charge, and he is in fact convicted.
Okay. I just want to emphasize, you might be about to go into this, but so the charge is that when he said, I did not murder Deidre Kennedy, and he said that was a lie. So to prove that is a lie, they have to prove that he killed Deidre Kennedy.
That's right. So this trial came on in 2000.
Yeah.
And yes, in essence, it was a retrial of the murder charge. It was a majority of the same witnesses being called, the same testimony being heard, that new evidence of the woman from Darwin giving evidence about the injuries to Carol's daughter, the evidence of Trevor of what he spoke to Carol about in prison, and the advanced dental forensic match that they had made with the bite marks.
Sorry, I probably should say that, you know, you can, there's a procedural mechanism where if you're charged a second time and you say, well, I've already been convicted or acquitted of this charge, there is a procedural mechanism you can argue that before you even get to the trial.
Can you say the French words?
Force acquit and force convict. I don't know.
I say it wrong every time.
Do you? Well, I don't know.
I say autrefois.
Okay, that's probably, no, that's much better. Let's go with that. Autrefois.
Autrefois acquit, autrefois convict. So this is in the code, and it's a plea.
Yeah, it's like a guilty, not guilty, plea. So that, I found the judgment, that was actually argued, and old Justice Muir, who is such a gentleman, he heard it and decided against it, said that the perjury charge was not breaching double jeopardy and that it could go ahead as because it was different enough, I suppose. Right. Yeah, summarising in a very broad way, his no doubt very good decision.
Yeah, that plea wasn't open.
So they then proceed to trial. He's then convicted at trial. It then goes up to the Court of Appeal.
Yes, it did. And so Court of Appeal, his legal team argued that it should never have been allowed. It was essentially a do-over of the murder trial, and it breached the principle behind the law on double jeopardy.
Yes.
So although it didn't breach the double jeopardy laws themselves, it was breaching the principle.
And am I right in saying that there was some in the law as it was written in the code, there's some provision that perjury doesn't, you know, double jeopardy doesn't apply to if you're bringing a perjury charge. It's different enough from whatever the original charge might have been that you could
How could that be in the law in these guys?
Well, that's what I thought you were getting at when you said it was really against the principle rather than the written word of what's in the code.
I don't know about that particular exception, but if we think about the importance of principles in our system, I mean, some of the things that we hold most important are principles rather than laws. The right to silence, the right to a fair trial, you know, the burden of proof, all of those things. So it's a fairly persuasive argument to say that an important principle like double jeopardy is being breached. And that held a lot of weight, obviously, with the Court of Appeal because that was, in fact, what they based their decision primarily on, that this was a breach of double jeopardy, a breach of finality for Raymond Carroll.
So we'll probably explain finality. That's a principle. It's related to double jeopardy.
Yes. So if you have been brought to trial, if you've been investigated, charged, brought to trial and had a resolution to your trial, you have an expectation of finality, that matter is now done and you don't have to live with it hanging over your head, unsure if you're going to be brought back into the system.
Yeah. And the Court of Appeal accepted all those defence arguments.
Well, they didn't like the jailhouse
snitch argument
testimony.
I wonder why.
They said he should never have been allowed to testify.
Yes.
They also thought little weight should have been placed on the witness from Darwin.
Yes, I agree.
They said that there was some differing opinions about the forensic dental evidence, which was concerning.
Yes.
So they said the jury's decision was unsafe and unsatisfactory, but also that the entire trial had been an abusive process on the basis of the double jeopardy.
Yes.
So he was allowed to walk free.
Yes. And then interestingly, there's an appeal allowed by the prosecution. So usually if you're acquitted by a jury, prosecution can't appeal. But if you're acquitted by a court of appeal, the prosecution can appeal.
Which they did to the High
Court.
All right. So the High Court said none of the evidence that was presented was new and compelling.
Yes. Oh, so can I just jump in and explain that,
sure.
since I have written a thesis on fresh evidence? All right. So what I find is most people, lay people, lawyers, have heard this term fresh evidence and new evidence and have some idea about what it is. But in short, it's evidence that the jury didn't hear, that somehow you've found out about after the trial. And there's a distinction between new and fresh evidence about whether it came about, you found out after the trial when you should have known it before the trial, and a few things like that, which we don't need to worry about. But the High Court sound like they had some, I should say, because the jury trial is so important in our criminal justice system, courts of appeal don't like to usurp the role of the jury and take over from them. And so if there's information that the jury should have heard which they didn't, often that means that the matter will be sent back to be heard by a jury. So your conviction is quashed, but you're ordered to be retried. And so there are some rare occasions when the evidence, this fresh evidence or new evidence that's before an appeal court is so compelling or so persuasive that the court doesn't bother to trouble a jury with it. They make the decision themselves that you're not guilty, so you're acquitted, and your conviction quashed and you're acquitted. And so that's what the High Court says in this case.
Yep. And so that obviously is the last option in terms of the system. So if the High Court has made a decision, there's nowhere to go from there.
That's right.
So 2 acquittals, no charge, no conclusion to Deidre Kennedy's murder. No one has ever been held responsible for that. That's the end of the legal matters for Raymond Carroll.
Yes.
So what happened next? Well, it was again not taken, all that well that he was free again. There was still this sense of injustice or dissatisfaction. And Deidre's mum, Faye, she started to work towards some legislative change. She was in contact with people in Parliament.
Yes.
She was pushing for what she wanted to be called Deidre's Law to be brought in, which would in effect mean that someone like Raymond Carroll, who had been acquitted of a murder, could in fact be retried for that charge if certain criteria were satisfied legally.
Yes.
So that this kind of scenario wouldn't happen again.
Yes.
And it did take some time. So that perjury trial was 2000. I guess by the time the High Court finished with it, a couple of years would have passed.
Yes. Well, I wonder if this is so that our listener, Jessica Hodge, who suggested this, said she recalled that there was a petition at the local newsagent in Ipswich for people to sign. And I wonder if that was a petition about changing the law.
There was a petition. In 12 weeks, she got over 33,000 members of the community.
33,000, wow.
Showing their support.
Yes.
What happened was this push for change was effective.
Yes.
We can't always say that. Often it does not result in change, even though people might sincerely desire change.
Sure. Change isn't always good though. So.
No. But so this did happen. And so in 2007, Queensland's law was amended so that a person who had previously been acquitted of murder.
Yeah, it was restricted to very serious charges.
Murder and manslaughter.
Murder, manslaughter, and wasn't there treason or something?
Separately. Well, so one provision is if you've been acquitted of murder or manslaughter, you can be retried.
Yep.
The other is if you have been convicted of an administration of justice offence, so perjury, jury tampering,
yes,
obstructing the course of justice, those sorts of things.
Yes.
And fresh evidence came out, you could be retried.
Yes. And sorry, I want to say two things about that. So the test is fresh and compelling evidence. Yeah, it's a
fresh
phrase,
and compelling. That's right.
And that has been determined by the Queensland courts and then subsequently other courts to be a very high threshold.
Very high threshold. And not only that, it has to be fresh and compelling, and then also say that it's in the interests of justice to retry. So it's not even enough to show that it's fresh and compelling, which is very difficult to do. But then there's that little possibility that one of the key players might decide not in the interests of justice.
Yes.
So it's another threshold to pass.
Yes. And Queensland were the first in Australia to pass that legislation?
Let me tell you, New South Wales was 2006-ish as well.
Right.
So New South Wales, they were very affected in New South Wales by the Carroll case.
Oh, really?
Yep. In the second reading speeches that I read, or the debates, there was a huge focus in New South Wales for the double jeopardy laws to be amended because of a different case altogether, the Bowraville murders.
Yes.
Which we don't know if we'll go into that today. But also, when they were discussing that, they also talked about Raymond Carroll and Deidre Kennedy. So it definitely had far-reaching consequences in terms of legislative reform. So that was also around 2006. ACT in Victoria did not, at that point, make any changes. They refused. But then 9 years later, the ACT did.
Because it's a big, I mean, as you pointed out, double jeopardy rule, 800 years old. You know, double jeopardy is the kind of,
foundational.
It's a foundational principle. It's a legal principle that lay people know. I think you'd probably stop somebody in the street and say, what's double jeopardy? And their answer would get, in the ballpark of what it is.
Right.
So to change that or go behind that, you can understand as something that governments might be a bit hesitant to take up.
So I mean, that's amazing that we got those amendments in 2007.
Yes.
What's not so amazing is that there have not really been any concrete flow-on consequences from those amendments.
In a sense of
a legal sense. So
nobody's ever been retried under them.
That's right.
Yes.
So, I mean, initially the 2007 amendments, they put in those requirements, fresh and compelling in the interests of justice.
Yes.
It was not retrospective. So that meant that it would only apply to matters that were heard from 2007
onwards,
which, I mean, if we think about the reason there was such a push, it was because of older cases where new evidence had come to light.
Yes.
So none of those cases would have been eligible.
I'm not sure there were too many. I think this is quite a rare, I mean, I don't think there have been many applications.
No, there haven't, but it meant that they were precluded. Yeah. And particularly Carroll's case was precluded, which was the impetus behind the change, let's be honest.
Yes.
But that issue was addressed in 2014 when there were further amendments to recognise that Carroll would not have fallen within the amendments. Like, there was specific reference to that case again in the amendments.
Yes.
Oh, sorry, not in the amendments.
In the second reading speech.
Yep. And so then it was retrospective. And so, I'm following along with this.
Yes.
Thinking, great, this is going to be some real legal reform and change that I can teach my students about. We're going to get some justice here. Crickets. Yeah. No cases, no retrial, no recharging of Carroll. And then in 2019, there was an application for a retrial under the exceptions.
Not in Carroll's case?
Not in Carroll's case. It was another case. It had to do with DNA on a pillow in a bedroom.
Yeah.
I won't go into depth on that case, but the end result was that the application for a retrial was denied.
Because the test is so high.
Because it was so high. So I did look at the reasoning of the court in that case.
Yeah.
So let me just tell you. Okay. And interestingly, the Chief Justice in this case was Walter Sofronoff.
Oh, the President of the Court of Appeal.
President of the Court of Appeal, who has recently been instrumental in
the DNA
the new
inquiry.
push for reform to DNA laws.
Yes.
So I think that's nice.
Yeah. Nice little
symbiosis.
Yes.
Is that a word? That I'd use it.
Oh, I like that. Yeah, symbiosis. We should throw it in more often.
So, what I thought was interesting from the TAL case, TAL,
A pseudonym.
Yeah, he couldn't be identified for a variety of reasons. Was they had a look at some UK cases because our amendments were broadly based on similar laws in the UK.
Yes.
And in the UK, some of these cases have been retried.
Yes.
Which is further ahead of us. So they first had a retrial in 2007.
Yeah.
That was in relation to a murder. It was admittedly a circumstantial case. In that case, he was acquitted. But then some years later, he was sentenced to imprisonment for other offences. And while in prison, seemingly in aid of his own rehabilitation, he confessed to the murder.
Ah, wow.
So he was at once charged with perjury. And during the investigations, he again admitted his guilt.
Yeah.
And he was convicted of the perjury, sentenced to a term of imprisonment.
Yes.
That all happened before the reforms came in.
In Queensland, okay.
No, in the UK.
Oh, really?
Yep. So then when those reforms came in, the prosecution applied for a second trial for the murder that he had originally been acquitted of. And the Court of Appeal found in that case the confessions constituted new evidence, which was not merely compelling but overwhelming, and did order the new trial.
Wow. And then he was convicted not only of the perjury, but then of the murder itself.
Yep.
Wow, okay.
There was another one in 2009 where an elderly grandmother had been raped in her home. There was no question that she had been raped. And the respondent or the accused was charged. He denied committing the offence or ever having had sex with the victim. He did have an alibi. The victim in that case gave somewhat contested and not very persuasive evidence identifying him as the offender. And the rest of the case was circumstantial. So he was acquitted and the victim died. But years later, the accused's DNA was coincidentally matched to a sample of sperm that had been found in the victim's vagina and which had been preserved. And the court held that this was new evidence that not only confirmed the victim's identification of the accused, but demonstrated the falsity of the alibi evidence. And that was, of course, evidence of guilt. And that DNA evidence was deemed compelling and admissible.
I wonder why they didn't do it at the time of the original investigation. Presumably that's the first thing you do in a rape case.
Well, that appeal was in 2009.
Yeah.
So I'm guessing it was earlier than that because
so DNA,
he got acquitted, then he had other charges, he got convicted, then the victim dies. So I'd say there's been a passage of time. So maybe the DNA evidence wasn't.
Yeah, interesting.
All right. Another one. Oh, yeah, okay. So this was one where a woman had been attacked and she had suffered severe head injuries from which she did later die.
Yes.
So the accused is charged with her murder. The evidence, again, was circumstantial. It included his having been seen in the location where she lived, as well as some differing and suspicious accounts he gave to police about his movements on the day in question. There was a questionable footprint that may have been his. His boots were examined. No blood was found on them. And he denied murdering the victim.
And he was acquitted by a jury.
Yeah. He acknowledged that he knew her. He said he'd only rarely seen her, hadn't seen her on the day she was killed.
Yeah.
Yes, he's acquitted. 10 years later, another examination of the boots revealed traces of the victim's DNA, which, on the evidence, must have been deposited in her wet blood. And the Court of Appeal accepted this evidence as highly probative and, in effect, decisive in the case, therefore meeting the threshold.
And he was retried?
Well, I'm guessing so.
Yeah.
Yeah.
Interesting. So in Britain,
it's not so difficult to retry.
Yeah, I wonder what the test is. But they certainly try to. I mean, it's not just in Queensland that we've got a strict test. It's that applications weren't being bought. I mean, I think that one in 2019 was either the first or the second ever bought.
I'm pretty sure it was the first.
I mean, well.
And it made headlines.
You got to be in it to win it.
Like,
I mean,
there was front page headlines about the fact that they were applying for a retrial.
Yes.
Obviously, they didn't know which case it was.
Yeah.
It was like the general public were interested and invested to see what was going to happen.
Yes.
And then nothing.
Yeah, but I don't think that's a test of anything, is it?
I would like to know why.
The Roman Colosseum where we can all sit there and gawk over horrible things.
I think part of the problem is that the threshold test is so high that it probably is not pursued because of a knowledge that it will fail. And so I think, is that then a problem with the threshold test? You know, rather than a lack of cases that could in fact be dealt with if it wasn't such a...
My recollection, and you would know better than I, was that after 10 years, so this legislation was brought in 2007, after 10 years, 2017, there was some kind of review of the legislation.
Yeah, I think so.
I don't know whether they said anything about that. I mean, there's a lack of empirical evidence because there's only been one application. So
yeah.
We don't know from that standpoint, but maybe you're right. Maybe the culture in the prosecution department is that there's no point bringing him, you'll never win.
Well, I mean, it's hard enough on an appeal to argue new and fresh evidence.
Yeah, but the prosecution are never arguing that. The defence are. So,
but I don't know why you'd be complaining about it. The precedent. That's the...
Yeah, but I mean, one of the other principles behind the idea of making it a very strict test, besides the fact that it's going against double jeopardy, is the idea that you don't want to allow the prosecuting service, the police, to just do a sort of a half-assed job on the investigation on the basis, we'll just have a second crack later on if we don't. Oh, look, we found this stuff. Oh, it fell behind the photocopier. Oh, here it is. We better... why don't we have another go? So to hold the prosecutors and the police to a very high standard in terms of the initial investigation and trial, get it right the first time,
which is best
it's
for
very
everybody.
hard to get absolutely, it's best for everybody. But I mean, I think that's an important principle to understand behind it as well. That they don't want to make it too easy, lest it encourage police and prosecutors not to do their utmost in every investigation and trial.
But I can tell you as well, like running a retrial is not something the prosecution loves to do. So,
but the statistics are that they win retrials more often than they win ordinary trials.
Is that right?
Yeah. Yeah, the number of times people go, I've got a retrial, and you're like, good luck, because the prosecution have seen the defence hand by that stage.
When you say win, you mean they get convicted for a second time?
Convicted on, the chance of conviction on a retrial is much higher than it is on a first trial.
How does that even make sense? Because they have to have been convicted the first time.
Oh, sorry. I thought you were talking about when there's a hung jury or.
Oh, okay. All right. But you meant after an appeal.
Yes. No. Sorry. Yeah. You get convicted, and then you're retried, and then you're just convicted again.
You've already been convicted. Yeah. Anyway, it's also not something that prosecution would be trying to do, is run a case for another time. All right. So it's not quite the end of the story. I mean, it is for Carol. We have no more about him.
Yeah. Well,
in fact, I searched in depth.
Yes.
It's like he's vanished off the face of the earth.
Yes.
Like I don't know if he is still alive. I don't know if he's moved or if he's died.
Yes.
There's just, which I don't blame him, I suppose.
No, you would want
but
to
nothing
disappear.
about him. I think at one point he did go on 60 Minutes or something like that.
Right.
And I'm pretty sure he took a lie detector test and he passed.
Yeah.
But the interviewer, I think, still said to him, but, isn't it just that you've convinced yourself that you're not guilty?
Well, they can have their cake and eat it too. If he fails it, they're like he's guilty. If he passes it, they go,
but so even then, I think that was in the 2000s.
Yes.
Late 2000s.
Yes.
He was still adamantly saying he was not guilty.
Yeah.
So, I mean, we have to recognise he has never wavered in his position that he is innocent.
Yes.
And according to the laws, he is.
Yes. Well, he's got a fantastic record on appeal. He's won every appeal that he's gone to. He's won, which is amazing for a defendant.
I mean, I know you have some issue with the odontology, but I also think if you did your 10 mouths and lined them up, and they picked his,
great.
Then how would you feel?
Run it.
How would you feel about the fact he's now been acquitted twice?
Well, I think what I try to keep in mind is that the system is designed not to convict innocent people. It is not designed to convict all guilty people. So that means that you are going to have guilty people that get away. That's just a cost that we have in our system because we focus on not convicting innocent people.
It's that saying, isn't it? Better to let
10 guilty men go free than have one innocent person convicted. Yes. So, and I think that in the public commentary I see and read about criminal law, it seems to be forgotten that we are trying not to convict innocent people. If we wanted to convict every guilty person, we absolutely could. But in that process, we would be convicting a lot of guilty people. You know, it's just like those gigantic fishing fleets that go out with the enormous nets that go to the bottom of the sea and just pick up everything. Yeah, they catch all the fish they're looking for and a whole lot besides. So we could make the investigative procedures so tough for defendants and the trial procedures so tough for defendants and so pro-prosecution that we are convicting lots and lots of people, and we'd get every guilty person, but we'd also get lots of innocent.
Or it'd
people.
be like the witch trials, wouldn't it?
It'd be like, exactly. I think that's a great point. The Salem, was it Salem?
Well,
witch trials?
So many, but yes, Salem.
Yeah.
So you died if you're innocent, and you were killed if you were guilty.
Yeah, that's right.
And you didn't have any opportunity to give call evidence, defend yourself. Yeah,
I
know. I respect the system. I do. But so let's finish on a little bit of recent movement in double jeopardy laws.
Yes.
So I think, have talked before about the DNA lab and the fact that tens of thousands of samples were not correctly tested, which means that if they are now correctly tested, it could uncover evidence in cases that have already been dealt with.
Yeah. So in Queensland, because of the work of Hedley Thomason, one of his podcasts, it came to light that the testing procedures at the forensic labs that were used by the police were not doing the right thing.
Yeah. And
so that there was an inquiry into it led by Walter Sofronoff, and all of this was exposed publicly. And so there's been a clean out of and a complete organisation of the forensic labs. But now there's this problem that there's potentially a whole lot of guilty people out there whose DNA was not properly detected when it could have been, but they've often gone to trial, been acquitted, and then because of double jeopardy, can't be retried. But why doesn't the new legislation cover it, Lizzie?
So the new legislation might, but even with the 2007-2014 reforms, it only applied to murder and manslaughter or the administration of justice offences.
Perjury,
And so a lot of these samples relate to other types of offending like rape, sexual offences, burglaries, assaults, and of course murders and potential manslaughters. So should these DNA samples be tested and identify positively, allegedly, someone as the offender who has already been tried for a rape?
Yes.
We still have no provision in Queensland to retry that person because it might be fresh and compelling and in the interest of justice, but the legislation doesn't allow that type of charge to be retried. So we do have a new bill before Parliament, and I think they started back very recently, so maybe it'll be on the agenda. And so they are expanding the double jeopardy exceptions, so you could have a retrial to a further 10 offences to cover things like rape, sexual offences, assaults, that sort of thing. So attempted murder, unlawful striking causing death, killing an unborn child, incest. So all of those will now be covered. And it clarifies that for the double jeopardy exception, evidence is defined to be fresh if it was not presented in trial and could not have been through reasonable efforts by the police and prosecution.
So I was going to explain that. Okay. So, I mean, because the problem is even if these changes go through, the argument might be, well, the police and the lab had this evidence and they didn't test it properly. So it's not fresh evidence. They had it, they knew it, they tried it, didn't work. So it's not fresh. It's only new evidence, and there's some other rules around use of new evidence, which generally makes it harder because the system is designed to try and make sure that the police do it right the first time.
Yes.
And by not allowing, things like this to come in. So they've now got to legislate as well to get around the fresh and new evidence test that this DNA will, effectively under that test you just read out, be deemed to be admissible, fresh, compelling.
Yeah,
whatever.
so that is the hope that's how it will.
Not
in
my
fact.
hope. I mean, these are.
Well, you don't think these reforms are good?
I haven't got a concluded view, but I'm very concerned by them because this is what happens. We have some ancient principle on which we operate our criminal justice system. We decide through legislative change to pare that back a little way, and then as time goes by, it's pared back more and more. And we see this with the right to silence. I mean, I'm sure you teach it. The right to silence was sacrosanct, but over the years, there's been, legislation that in certain circumstances, there's no right to silence if you're being questioned by the Crime and Corruption Commission, for example, and if you're pulled over by a police, or if the police officer asks you the registered owner of a car who the driver was, they have to tell them.
Yeah.
And so, and this is, I think another example, we have double jeopardy has been pared back for a very specific reason, and now that's being broadened.
It has been broadened, but I also feel like the right to silence has been eroded, and that's from a prosecutor's point of view. Like I do have some concerns about that. But if we don't amend these double jeopardy laws in this way, we are talking so many potential injustices because of the DNA lab's systematic failure to test properly. What other option do we have?
Well, as I say, I'm not saying we should do this, but you'd need to appreciate that an opportunity cost of our system is that guilty people get away.
But this is a lot.
It's a lot of
potentially a lot.
Potentially a lot.
I know, and I think the hesitation is natural, particularly from a defence perspective. But if we're thinking about, yes, the rights of an accused to a fair trial should be paramount, and I agree with that. But also, they're not the only rights. You know what I mean?
Sure.
So we can't ignore the rights of the victims and the rights of the community to have justice be served properly, and it hasn't been because of the DNA lab.
Well, so there's a potential that it hasn't been because
there will 100% be cases where that is established, that there was not justice because of the lab's failures. I do not believe that in the tens of thousands of samples, we're not going to solve cases that currently are not resolved.
Statistically, you're probably on a safe bet there. But just so that people understand what you mean. So that means that a sample is retested and it is then identified. It's not conclusive the person's guilty. That is then just evidence that will have to go before a jury with other evidence to see if that person is guilty.
That's right. So we're not saying, let's just convict all of these people whose samples weren't tested properly. We're saying, let's now put it back before the system that is designed with the rights of the accused in mind. So it is opening the door to a retrial, yes. But we opened that door in 2007.
I know, just a little way, and now we're opening it further.
But I think in some cases, if we're thinking about our victims, of course, the family of a murder victim, you cannot quantify their grief. But it's a life sentence for a rape victim, for example. They live with that for the rest of their life. It affects potentially every aspect of their life.
Yep.
So why are they not just as important in terms of a type of offence that should be open to this exception? It becomes this judgment call on, well, murder and manslaughter are the worst. Well, are they the worst in terms of impact on victims when you think about the living victims who that is going to colour the rest of their life? I don't think it's right to say, well, we'll allow it for the murder manslaughter, but the rest no. I think we have to acknowledge all of these are victims of very serious crimes who have been potentially exposed to injustice, and that needs to be addressed. So I cannot wait for these provisions to come into force, and let's just see what...
It's in bill form, isn't it? It hasn't
Yes,
passed
I'm saying
the
I
Parliament.
can't wait.
There's an election coming.
Not for 8 more months. Let's get it through before then. Come on, Parliament. Anyway, so that is definitely... This is not, we haven't closed the story on double jeopardy. I think there's going to be more to come.
Yeah, so the horrible murder of Deidre Kennedy back in 1973 still reverberates in 2023, 2024, 51 years later.
Yeah, definitely that case was a huge impetus to change.
Yeah.
Which I think is, I feel for the Kennedys, but I think fantastic for other potential injustices.
We will see.
Oh, that last little eye roll, you had to get it in. So thank you to our...
Jessica Hodge, thank you. I hope she seemed to have great hopes that we would do a good job of it. I hope we have.
Nervous for the verdict now.
I hope she'll message me and tell us.
But thanks, Joe.
Thank you, Lizzie. Again, you've done such an incredible amount of work.
I love a good... Well, I shouldn't say good story, but I like to sink my teeth into...
Absolutely. I can't believe you read second reading speeches. That's unbelievable.
I love a good second reading speech.
Yeah.
Parliamentary debates. Why not?
Yeah, jump in. All right. Thanks, Lizzie.
Bye.
Thanks for tuning into this episode. You can find links to the cases that we discussed in the description. You can also find a link to Guardian Criminal Law, and a big shout out to them for making this podcast possible.
The majority of criminal cases involve people, normal people, people like you, people like me, who find themselves in an unusual set of circumstances that would not usually occur in their life. My name is Mark Savick, and I'm here to assist you with your criminal matter. I look forward to hearing from you and being of assistance to you.
If you're interested in clips, you can look at them on Instagram and TikTok. Just search for Justice Matters Pod. See you next episode.